Welcome to Case of Interest, Kohberger. Thanks for joining us. It's been a few weeks since we had an episode, but we're back with a lot of new information in the Brian Kohberger case. We try weekly to do episodes as this case develops. We're here in northeastern Pennsylvania. This case is occurring out in Moscow, Idaho, where 4 University of Idaho students were murdered in November of 2022. And then weeks later, about 12 weeks later, an arrest was made here in our area in Monroe County, Pennsylvania. Brian Kohberger arrested for all 4 of those murders. He was a student at the University of Washington, or Washington State University, I should say, when these occurred. And we're learning a little bit week by week as documents are posted online and made public, leading up to a preliminary hearing that's scheduled for late June out in Idaho. We are going to have to continue speculating based off of these public court documents that are released weekly in Idaho, because we have just learned one of the big items that we want to talk to you about this week, that the gag order in this case that restricts all law enforcement officials, all prosecutors, investigators, as well as all of the victims' families from speaking publicly about this case is going to remain. A coalition of media, which includes our parent company, Tegna, went to the Idaho Supreme Court asking to have that very restrictive gag order lifted. But we learned this week that that's not going to happen. While that's bad news for us, journalists that are covering this case, it's also unsurprising news. I want to take a look at the document, the order that was issued by the Idaho Supreme Court earlier this week. The main argument that the 3 judges make is that the coalition of journalists just did not file the lawsuit in the right arena. I'm going to highlight this in particular, where it says, "We are also mindful that under the circumstances presented here, granting petitioners," that's the media, request would essentially invite the media and others to bring a direct challenge to this court, meaning the Supreme Court, anytime a trial judge issues a non-dissemination order, or gag order as we commonly call them, or admonishes the attorneys not to discuss the case with the media without first attempting to resolve the issue before the court issuing the order. Basically admonishing that coalition of media for not doing things properly and going directly to the Supreme Court to have this handled. So there's the decision that the gag order is not going to be lifted, which is not something that experts that we have checked in with throughout this case expected to happen. Not exactly surprising. The biggest news maybe this week that we learned is out of court documents filed in Nevada, in Reno, Nevada, which is where one of the 2 surviving roommates in that King Road address in Moscow, Idaho, is living now, because she was subpoenaed by Brian Kohberger's defense team to testify at the preliminary hearing in June in Idaho. She and an attorney fought that subpoena, saying that the preliminary hearing should not be an arena where such a witness is questioned, because that essentially turns it into a mini trial, which is not the purpose of a preliminary hearing, something that we're going to be discussing in just a few minutes. And then just yesterday, in more court documents in Nevada, it is on paper that surviving roommate has agreed to do an interview with Kohberger's defense team, because the defense says she may have exculpatory evidence in this case, which is evidence that could point to someone else having committed the murders, not Brian Kohberger. There's a lot to unpack there. So we turn to a legal expert, Brett Regal, out of Stroudsburg, Monroe County, where Kohberger's from, to help us understand what's going on here. So let's listen into what he has to say. We're joined by Brett Regal of Arm Lawyers in Stroudsburg. Brett, you've been a great resource to us as we've followed this case as it's developed. And we have some pretty big new information that shows a little bit more of that defense strategy, which is the last thing we talked to you about. Just wondering, taking a look at those documents out of Nevada courts that were released this week, what do you think the subpoena of the roommate, now this agreed interview, might mean?
Well, let me back up and say thank you for having me. It's a pleasure to be here. And I'm enjoying the opportunity to look at these things and have a discussion about them. I think kind of the spot where you have to start is that what we have is basically a preliminary hearing coming up in June. Just like in Pennsylvania, the preliminary hearing is only about probable cause. It's not about guilt or innocence. It's about, is there some evidence that a crime was committed and some evidence that this is the guy that committed the crime. What it looks like was happening is that the defense has come across some information that they think is helpful. They want this young lady to testify, but she is in Nevada, so they have to invoke what's called long arm jurisdiction to get a subpoena that's effective there. That happens all the time in every state, very commonly here, because Monroe County, for example, where I practice primarily, is just across the river from New Jersey. People work in New York a lot. There are oftentimes witnesses to things that are from an adjoining state. And if they agree to come voluntarily, wonderful. If they don't, you have to go through a process that is slightly unique to each state to get the subpoena to be enforceable in that person's home state. And that's what they started here. When they filed the request, what's happened is that an attorney now that represents the witness stepped up and said, no, I don't think that you did it right. Number one, I don't think that this is a material witness for the preliminary hearing because of the limited scope. Number two, no judge decided that this is a material witness, so you can't enforce it. Then number three, there was no hearing to determine whether there's a hardship or the necessity of this witness to appear. If the witness is material, then we have to look at whether it's necessary that they appear and whether or not it puts a hardship on them. But the whole thing kind of ended because the attorneys for the witness were able to agree with the defense that at this point in time, they'll produce this person for an interview. And there was then on the record order established so that the witness can't back out of doing that interview.
There's a couple definitions that I think we should make clear, because I don't know if viewers, there are words we hear a lot, but I don't know that viewers necessarily will know what they mean. What does a material witness mean? And also there's a mention in that paperwork that this roommate may have exculpatory evidence. What does that indicate?
So let's take exculpatory first. Exculpatory, there are two words that will be heard constantly when we're trying to characterize evidence that is relevant and material to a case. And it's either going to be inculpatory, exculpatory, or sometimes we may have evidence that's being used purely to impeach. So inculpatory means it's something that tends to prove guilt or criminal responsibility. It could be that it proves that this is the person who did it, or it could be something that helps prove their mental state as part of the case. Exculpatory either tends to back away from the mental state, provide evidence that the mental state that the prosecution is looking for isn't there, or that this person is not the one who committed the crime. Easy example would be if there were two people that could have been driving a car that was involved in say a DUI collision. Nobody saw who was behind the wheel, and there are two individuals who have been injured from the car. Well, it's some circumstantial evidence that is inculpatory that one guy is on the driver's side and one guy is on the passenger side. But it could be exculpatory if somebody, a witness, were driving down the road and say, right after that crash, I saw those guys get out and switch sides. So that's what inculpatory means, proving guilt or proving the state of mind necessary for the particular crime. Exculpatory means disproving guilt, challenging guilt in some way, or changing the state of mind that is necessary.
Yeah, that makes sense. And one of the interesting things here is that there are two surviving roommates that we know of. There's testimony from one in the affidavit that originally charged Brian Kohberger that gives pretty inculpatory evidence that describes a person about his height with bushy eyebrows and a big nose, and it kind of fits his description. We have not heard anything from this other roommate, who we know is living on the first floor of the home, which is where not the one floor where murders did not occur. So we have not heard anything from the prosecutorial side about what she may have to say. So of course there's a lot of speculation about what she could have that's exculpatory. And I'm not asking you to speculate too much, but could it be as simple as the fact that she didn't hear anything? Would that be
Sure.
considered exculpatory evidence?
Sure. Didn't hear anything, saw someone else in the area at the time, heard something after this individual left that is inconsistent with them having been killed at the time that would be consistent with when he's alleged to have been there. Because bear in mind, we've got a pretty, not huge, but a passage of time on our timeline between the discovery and the time at night that the individual is seen, if I'm remembering the facts correctly. There's a few hours in between. So, is there a question as to whether or not somebody else was in after Kohberger was there, or the person that was described to some degree? Does her description of the individual not match Kohberger at all? Does she say, well, yeah, I saw a person leaving, but they were short, blonde, and and had startling blue eyes, or whatever it may be, that makes them sound like a very different person than Brian Kohberger?
It could be anything that could potentially cast doubt on the information that has been presented in the affidavit.
Correct, and that's part of why the way that the attorneys on her behalf were kind of defending on the idea of, well, this isn't trial. You may well have a very different position in terms of being able to make this witness come at the time of trial. This is a preliminary hearing, so it really doesn't matter if you have two witnesses coming to a preliminary hearing, one who says these are the facts that support guilt and identification, and one who says that's a load of hooey. Here's all of the reasons that is a mistaken identification or not what happened. For probable cause purposes, this person doesn't matter. And you're left with the elements of the crime having been met, and there being enough to get the case through to trial. And that's kind of what the issue is in terms of materiality. Materiality is essentially whether or not something is both relevant and important to, and how is it linked to what's going on. So, for example, if the roommate said at 2 o'clock in the afternoon the day before, I saw a guy that looked like Brian Kohberger wandering around, and that's the extent of the evidence, not going to be terribly material to what happened overnight. But if the roommate had communication with the person that was leaving, or was able to positively identify somebody else, that could be substantial, just not substantial to the question of probable cause.
Since we're talking about probable cause, could the contents of this interview that's going to happen between Kohberger's defense team and this surviving roommate, could that come into play in the preliminary hearing, or is that something that we won't really necessarily hear about until trial?
It's more likely to be something that you would hear of at trial, but it is also something where the defense team could certainly use what is shared in the interview to set up questions that would be valuable at the time of the preliminary hearing, or valuable at the time of trial, or both. Somebody is going to take the witness stand in the preliminary hearing. That somebody is going to be subject to cross-examination. So depending upon how much room the judge allows in terms of latitude to ask questions, there might be questions that set up a clear battle of recollections, a clear battle of positions for observation, a clear battle of bias at the time of trial. So they could interview this young lady and she could say things that they're not going to ask directly, but they could ask, well, you didn't see anyone that night other than the tall, dark-haired man with the bushy eyebrows. No, I didn't. They know from their interview that this other person says there were 3 people, and that the tall, bushy-haired man was the middle one. Well, now they've got a conflict built in for the time of trial to establish that maybe you shouldn't rely on the eyewitness too strongly because he might not have had the best position to see or the best ability to remember, or he may have a hidden reason that he is suggesting this is the truth when it isn't the truth. I mean, you don't know whether or not the angle that's being taken is this witness is dishonest, this witness is mistaken, or this witness isn't nearly as much of a witness as they want to be.
Hmm.
Because there's a difference.
Do you think we'll expect to see more of these subpoenas going out to other people who may be called to testify, either for the defense or the prosecution?
I think it depends upon where they've gotten in their investigation, which is, of course, something that they're going to be holding very close to the vest. It read to me like this was a situation where they're not getting much success in trying to make this young lady be cooperative in her home state. So they tried to find a way to put pressure on her to come to a place where she would not have a choice about appearing and would not have a choice about testifying. And then the way that it was solved was that her attorneys and the defense attorneys agreed that she would be produced at a convenient place and convenient time for an interview.
Interesting. So there's a lot more still to learn about what the defense strategy could become this June 26th preliminary hearing. And we want to thank you for providing your insight and helping us understand, what is out there at this time. So thanks, Brett, for your time.
My pleasure.
So again, that was Brett Regal of Arm Lawyers in Stroudsburg, shedding some light on what this subpoena to summon the surviving roommate, one of the surviving roommates who we have not yet heard from, might mean for Brian Kohberger's defense strategy. Now, moving over to the prosecutorial side, there's a little bit of a development there too. In court documents in Idaho, we now know that the Latah County prosecutors have asked for some support. There are going to be 2 deputy attorney generals, so state prosecutors, stepping in to help support the Latah County prosecution as they move forward with this case. All signs point to that not really meaning a whole lot, other than this is an enormous case that's going to require a lot of legwork leading up to a trial when that eventually happens. So this is just some help from the state, and the state is going to fund that help. The county is not going to do that. So we're going to have to see how that plays out and whether or not the state could play an even bigger role in prosecuting this case. Thanks for joining us, and we'll keep you updated as this case continues to develop.